As you know that patent rights are territorial, that is, Indian patent is valid only in India, and similarly a Japanese patent is valid only in Japan. In order to claim patent rights in a specific country, one has to file for a patent in that country. Majority of applicants select to file in the US after Indian filing. In this video, we will explore the advantages of filing in India first and consequences of filing in US first if inventor is a resident of India. This is Bindu Sharma here, Origin IP Solutions, India's leading IP and legal services providing company. US often is one of the favorite and lucrative destination for the applicants to file for a patent. For Indian applicants, where to file first is always confusing, mainly due to the fact that date of filing a patent application or prior plays an important role in the entire process, and therefore applicant does not want to lose on priority date. So this decision becomes difficult sometimes, and in this video we will discuss the advantages and disadvantages of filing in India first. Having a US patent is attractive for various reasons, like business opportunities in US are better than any other jurisdiction, enforcement of patent rights is effective, time taken for patent grant is less, US market is mature enough for buying or selling of patents, granted US patent is valued more by the investors. For all these reasons, at the time of filing for a patent, the biggest confusion that inventor has is where to file for a patent first, whether it should be filed in India first or US first. Before taking a decision on where to file first, it is essential to understand what Indian patent law says about foreign filing. The issue here is sensitive as well as critical, and lack of expert legal advice on the same may have fatal consequences. According to Section 39 of Indian Patents Act 1970, a person who is resident of India may file for a patent outside India in two ways. And in this, the first option is to file a patent application in India first, wait for 6 weeks, and then go for any kind of foreign filing such as PCT or direct filing in a specific country. If the applicant does not hear from patent office within 6 weeks from the date of filing application, this indicates that the controller does not have any objections with respect to foreign filing. In order to file for a patent outside India, the second option available is to take foreign filing permission from controller of patents, and this can be availed when the applicant does not want to file patent application in India at all and wants to go for foreign filing. This permission is usually granted by the controller within 21 days from making the request, and is required not only for foreign filing but also for filing a PCT application when the applicant does not want to file Indian application. Now here it's important to understand the term resident of India, which has not been defined in the Patent Act 1970, but according to Income Tax Act, an individual can be termed as resident of India if he stays for a prescribed period during a fiscal year, that is from 1st April to 31st March, either for 180 days or more, or has been in India in aggregate for 365 days or more in the previous 4 years. So this is the definition of resident of India, and we have a separate video to explain resident of India term. We will put the link in the chat box. Any person who does not satisfy these norms is termed as a non-resident. A resident individual is considered to be ordinarily resident in any fiscal year if he has been resident in India for 9 out of previous 10 years and in addition has been in India for a total of 730 days or more in the previous 7 years. Residents who do not satisfy these conditions are called individuals not ordinarily resident. The main rationale behind having Section 39 is to safeguard national defense and security. If the invention is relevant for defense purpose or atomic energy, the controller shall not grant permission for foreign filing without prior consent of central government. Such may be imposed secrecy directions, and the controller may give direction for prohibiting or restricting publication of such application if the invention falls in one of the classes notified by the central government as relevant for defense purposes. So, provisions of Section 39 do not apply if patent application has first been filed in a country outside India by a person resident outside India. So, if this is the case, the controller cannot prohibit publication of the application under Section 39 of Indian Patents Act. Now let's understand the consequences of Indian or US filing first. It is a myth that filing a patent application in India first and US later, one loses on the date of filing application and the US application gets delayed. The fact is that even if you file for a patent first, you can file the same application in the US as a convention application, and this can be filed immediately after expiry of 6 weeks from the date of Indian filing. At the time of filing patent application in the US, you can claim priority date from the Indian filing. That's why effectively it means that even though you file for your Indian patent first and US later, the same priority date can be maintained in the US as well. So you don't lose anything as far as date of filing patent application is concerned. When the priority is claimed from Indian patent application, the applicant has to submit in USPTO the priority document which is obtained from Indian Patent Office. Therefore, it actually does not matter where you filed your patent application first, but yes, it certainly is a better choice to either file for a patent in India first or take permission from the controller for foreign filing. And I would like to make it very clear here that if you file your patent application in India first, followed by US filing, then you do not require foreign filing permission from the controller. So this permission is required only when you decide to file in a foreign country without Indian filing. Violation of Section 39 provisions is not good idea, because the person may be punishable with imprisonment of a term which may extend to 2 years or with fine or both. Hence, it is important to either file patent application in India first, 6 weeks, and then go for foreign filing, or to take foreign filing permission from controller of patents. Now, before I finish this video, I would like to ask you one question, and you can put answer in the comment section below. The question for the day is, what is prescribed form and fees applicable to take foreign filing permission from controller of patents in India? You can just put your answers in the comment section below. In the instance where the applicant is a resident of India, it is important to consider filing for a patent in India first or taking permission for foreign filing from the controller before filing for a patent in foreign country or PCT, for the reason violation of this provision can lead to fatal consequences. I hope you found this video useful. You can put your feedback in the comment section below. If you want me to make a video on a specific topic, you can put your advice in the comment section below. Thank you so much. Thank you for watching this video today. For any queries related to our services, you can contact us. Email ID and phone number is given in the video description. See you again. Till then, keep learning, keep innovating. Goodbye.